The Bogosity Podcast, early and ad-free. Become a subscriber at Patreon, Subscribestar, or Discord. Use the links at donate.bogosity.tv.
Welcome to the Bogosity Podcast for the week of July 14, 2024. The podcast that scales with time. This is your host, Shane Killian. Let's osculate the news of the bogus. So it's the end of the Supreme Court's term with a lot of different decisions people have been talking about, but there's one we covered that isn't getting much coverage, even though it's really important. The Supreme Court has overturned Chevron. The case is Loper Bright Enterprises v. Raimondo, which was about the Chevron doctrine, where Congress passes incredibly ambiguous laws that should be void for vagueness, but the courts, instead of voiding the laws or siding with citizens, leave interpretation of these laws to what are styled as highly trained experts ready to interpret the law, who are really bureaucrats who are unelected, unappointed, and completely unaccountable. Not only that, but Chevron says that the courts don't even have the ability to second-guess these bureaucrats. It's really about the fundamental constitutional principle that the executive branch should not be doing judicial functions, because that's a blatant violation of separation of powers. I pointed out the time that Thomas, Alito, Gorsuch, and Kavanaugh had all expressed skepticism of Chevron. All they needed is either Roberts or Barrett to join them. In reality, they got both, with only Kagan and Sotomayor dissenting. Jackson didn't take part in the consideration of the case. The case was combined with Relentless Inc. v. Department of Commerce, though, where Jackson did join the dissent. The majority agreed with decades-long criticism that Chevron deference disadvantages the little guy in disputes with an extremely powerful administrative state. John Roberts wrote for the majority, Chevron defies the command of the Administrative Procedure Act that the reviewing court, not the agency whose action it reviews, is to decide all relevant questions of law and interpret statutory provisions. It requires a court to ignore, not follow, the reading the court would have reached had it exercised its independent judgment as required by the APA. It demands that courts mechanically afford binding deference to agency interpretations, including those that have been inconsistent over time. Still worse, it forces courts to do so even when a pre-existing judicial precedent holds that the statute means something else. Chevron turns the statutory scheme for judicial review of agency action upside down. And the problem is that, in the Chevron framework, the concept of ambiguity is itself ambiguous. Quote, experience has also shown that Chevron is unworkable. The defining feature of its framework is the identification of statutory ambiguity, which requires deference at the doctrine's second step. But the concept of ambiguity has always evaded meaningful definition. As Justice Scalia put the dilemma just 5 years after Chevron was decided, how clear is clear? We are no closer to an answer to that question than we were 4 decades ago. It brings to mind the point during arguments when Gorsuch mentioned, quote, this ambiguous ambiguity trigger that nobody knows what it means. And Roberts expertly brought down the dissent of the liberal justices, quote, the dissent proves the point. It tells us that a court should reach Chevron's second step when it finds, at the end of its interpretive work, that Congress has left an ambiguity or gap. That is no guide at all. Once more, the basic nature and meaning of a statute does not change when an agency happens to be involved. Nor does it change just because the agency has happened to offer its interpretation. So for the dissent's test to have any meaning, it must think that in an agency case, unlike in any other, a court should give up on its interpretive work before it has identified that best meaning. But how does a court know when to do so? On that point, the dissent leaves a gap of its own. It protests only that some other interpretive tools all with pedigrees more robust than Chevron's, and all designed to help courts identify the meaning of a text rather than allow the executive branch to displace it, also apply to ambiguous texts. That this is all the dissent can come up with after 4 decades of judicial experience attempting to identify ambiguity under Chevron reveals the futility of the exercise. The dissent was pretty much a joke anyway, since they engaged in blatant fear-mongering, and also, as Gorsuch explained in his concurrence, the dissent suggests that we need not take the APA's directions quite so seriously because the finest administrative law scholars from Harvard claim to see in them some wiggle room. But nothing in the APA commands deference to the views of professors any more than it does the government. So this should mean good news for the little guy when they're being harassed, bullied, and oppressed by the SEC, the ATF, the EPA, and so many other agencies who have just made up their own law in the past, and courts have just said they have to go with it because of Chevron. There are a few caveats. Although courts will no longer defer to agency interpretations of the law, they will still be recognized as experts, so there will still be a measure of deference to those agencies. Although, of course, the big problem is not when agencies act on expertise, but when they act on ideology or a political agenda. Agencies still have broad authority delegated by Congress, and Loper does nothing to rein that in. And under stare decisis, previous cases where the courts defer to Chevron remain in force and can't be appealed on the basis of Loper. It only applies to new cases going forward. And remember, the U.S. had a huge administrative state even before Chevron, so this decision isn't going to bring all of that crumbling to the ground. But it's still a big step in the right direction. Now we just need to overturn Wickard v. Filburn. If you're looking for a way to support this channel, but you don't have any spare cash and you can't stand ads, you can do so by generating your own cryptocurrency. Use the links at the bottom of the description to follow the link to Odysee.com to listen to the podcast and see all of my YouTube videos as well. Just watching videos will produce cryptocurrency for the creator and yourself. And since Odysee is always monetized and never censored, you'll have no problem seeing all the videos from your favorite creators. You can also use the library credits you create at Odysee to tip creators and even purchase paid content. Earn library credits through various rewards, including daily view rewards and the number of shares and invites. And you can interact with creators in all sorts of ways, including like and dislike, comment, boost a post by supporting it, repost it, and share to other sites, all while earning crypto for the creator. Easily monetize yourself and your favorite creators using cryptocurrency, without advertising. Use the link below to visit this channel on Odysee.com and see many of your other favorites there as well. So let's look at the status of some of the important AI cases we've been covering, starting with Cussart v. OpenAI, where OpenAI and Microsoft were accused of training ChatGPT on stolen personal data. And the status? It's over. The judge dismissed the entire case. As we covered, Judge Vincent Chabria panned their complaint as, quote, needlessly long and contains largely irrelevant, distracting, or redundant information, and contains swaths of unnecessary and distracting allegations, making it nearly impossible to determine the adequacy of the plaintiff's legal claims. He ruled, because the court has no way of telling whether the plaintiffs could adequately state a claim once all the mud is scraped off the walls of the complaint, dismissal is with leave to amend. But if the amended complaint continues to focus on general policy concerns and irrelevant information in a way that interferes with a clear presentation of the legal claims at issue, it will be dismissed with prejudice. Moreover, if the plaintiffs manage to state a claim that gets past the pleading stage, they should know that, given the way the current version of the complaint was drafted, it is unlikely that they or their counsel can be trusted to adequately and responsibly represent the interests of absent class members in a federal lawsuit. Dang! The plaintiffs notified the court that they were not going to file an amended complaint, so Chabria ruled, quote, Judgment is entered in accordance with the order granting defendant's motion to dismiss and the plaintiff's notice not to amend their complaint. The clerk of court is directed to close the case. It is so ordered. Stick it with a fork! Unlike them, in Getty Images v. Stability AI, Getty Images did file an amended complaint, but it was still full of hyperbole, histrionics, and marketing hype. And it doesn't seem to have fixed any of the terrible arguments they made before. Judge Jennifer L. Hall will rule on Stability AI's motion to dismiss after jurisdictional discovery is completed. Over in Kadri v. Meta, the case famous for having Sarah Silverman as a named plaintiff, Judge Chhabria just allowed the entry of more plaintiffs, including Mike Huckabee. That should make things interesting. This happens as other plaintiffs withdrew and dismissed their cases with prejudice. The discovery dispute is still ongoing, so we'll have to see what the result of this game of musical plaintiffs is. It's a similar situation with Tremblay v. OpenAI, where plaintiffs are trying to avoid giving discovery by claiming it's work product. That's the trend. The plaintiffs want everything from the AI companies, but don't want to give anything themselves. But when you have these outputs of AI that are oh so similar to their own IP, the question needs to be answered. How cherry-picked is it? How many dozens, hundreds, thousands, millions of outputs did they scour through to cherry-pick the handful that they included in their complaints? They're all trying to hide it behind work product. Judge Robert M. Illman has already denied their work product claim. We'll have to see how he rules on their objection, but I don't see it going any differently. The argument is that a guy asked ChatGPT to summarize Act 3 of Hamlet 3 different times and got 3 different answers. What that's supposed to prove, I have no idea. To me, it seems to go to the defendant's point that they could just run the query 1,000 times and pick the one that just happens to be the closest match. Their claim is, quote, "The order's finding of broad work product waiver is predicated in part on the factual inference that without knowing the account settings used by plaintiffs and without knowing the exact formulation of their prompts, defendants would be unable to replicate the same results. But neither OpenAI nor plaintiffs have submitted evidence to support the order's conclusion that ChatGPT can ordinarily be operated in such a way that the same results can be replicated by reusing the exact formulation of a prompt. Indeed, in general, it cannot. The attached Exhibit A demonstrates how even a single prompt fed multiple times into ChatGPT is likely to produce different responses. Therefore, the order's apparent factual inference that ChatGPT will produce the same output in response to a certain prompt is clear error." Well, that might make sense if you're a complete moron, but rational people know that computers are deterministic. ChatGPT has a number of different parameters that the user generally doesn't get to see, and one of those is a seed for the pseudo-random number generator. OpenAI wants to be able to look in their server history for these prompts and replicate them using all of the parameters, including the seed. They can then do it multiple times with different seeds, and if they get significantly different results, then busted! So overall, it's not going well for the plaintiffs in these AI cases, but there are still a lot of questions that we need court rulings to clarify. So we'll keep covering them. If you're on the Wi-Fi in a coffee shop or hotel, anyone on that network can get your traffic. Do you really trust all of those strangers? For that matter, do you really trust your ISP? A VPN can protect you from prying eyes, disguise your location, and even foil government censors. It's essential in this day and age, so go to vpn.pagosity.tv and you'll be taken to BoxPN. Starting at just $2.99 a month, you can get unlimited high-speed connections to VPN servers all over the world, and they don't log connections, so your privacy is assured. Traveling abroad, just VPN home, and don't worry about what those other governments are doing. Back at home, stop your ISP from traffic shaping and messing with the quality internet access you're paying good money for. You can connect from multiple machines at once, including your smartphone or tablet, and it supports all the secure standards, including OpenVPN and SSTP. Bypass sensors and surveillance with your own secure VPN connection. Go to vpn.pagosity.tv. Back to the Supreme Court. A decision that's bad for pain patients that no one else seems to be covering is the court ruling against Purdue Pharma. If you've seen my opioid scare playlist, now refreshed in a brand new playlist with additional material as well as linking material, hopefully resulting in things making a lot more sense, you'll know that the Sackler family got the blame for opioid overdoses, even though we know it wasn't pharmaceutical opioids that was causing the issue. It was heroin and later fentanyl on the black market, but an incorrect cause of death was routinely recorded, and the CDC was counting the deaths incorrectly. When the CDC discovered that around 2005 to 2007, instead of correcting the problem, they decided to cover up for it by hiring a PR firm. And everything everyone thinks they know about the opioid crisis comes from this PR firm, not from any scientific studies or data. Now, I'm not saying the Sackler family doesn't deserve to go bankrupt. They were doing some things with their money that weren't quite kosher. But what the Supreme Court says has the potential to continue to prolong and even cause suffering for millions of pain patients. The Sacklers had settled a massive lawsuit claiming that OxyContin was resulting in addiction and death, a settlement worth some $8 billion. That was tied into their bankruptcy claim, which the court just invalidated 5-4. Dissenting were Kavanaugh, Roberts, Sotomayor, and Kagan. Yeah, the conservative justices were on the wrong side of this one, overturning the federal court's bankruptcy judgment for basically no reason other than drugs bad. That means that it's open season for lawsuit against the Sacklers from individuals and state governments alike. Kavanaugh wrote, "Today's decision is wrong on the law and devastating for more than 100,000 opioid victims and their families. The court's decision rewrites the text of the U.S. Bankruptcy Code and restricts the long-established authority of bankruptcy courts to fashion fair and equitable relief for mass tort victims. As a result, opioid victims are now deprived of the substantial monetary recovery that they long fought for and finally secured after years of litigation." What he doesn't mention but should have is, it's potentially devastating for pain patients. In fact, they don't get a mention anywhere in the judgment or the dissent. In fact, it's hard to find anyone this decision is good for other than ambulance-chasing lawyers. The lawsuit was brought by state attorneys general with some scattered individuals to give their sob stories and spew their hysteria, such as Eddie Bish, who died from an overdose supposedly of OxyContin, but since we are among the few who know that these deaths aren't being recorded correctly, it's far more likely it was either a black market opioid or polypharmacology, taking two or more drugs that interact badly, such as taking OxyContin and drinking alcohol. In the words of Crystal Lindell of Pain News Network, quote, "The High Court's ruling means the Sackler family is now open to more lawsuits against it and that some of the previously decided opioid cases could now be reopened. That's not just bad for those slated to receive money from these lawsuits, it's also bad for pain patients. Continuing the opioid lawsuits will only perpetuate the anti-opioid zealotry that's infiltrated the medical community." The Supreme Court's decision, and by extension all of the future lawsuits, are just going to perpetuate the myth that Purdue did a horrible thing when they claimed, truthfully, that OxyContin wasn't as addictive as other opioids. In fact, Purdue's lie wasn't about how addictive it was, because that was absolutely true. No, their lie, which no one else except PNN is pointing out, is that they claimed OxyContin will last 12 hours, when it does good to last 6. That's been confirmed by outlets such as the Los Angeles Times. I can tell you firsthand that hydrocodone and oxycodone are supposed to last 6, but they barely last 2.5 to 3. My pain specialist confirmed to me that's generally the case for many patients, and the experience of many people posting to pain management forums says the same thing. So what this means is that patients aren't prescribed enough pills to get through the day, meaning that either you suffer more every day than you have to, or you take additional pills to properly get your pain levels down, but they don't last the month. And in the meantime, since you're taking the pills in a manner inconsistent with the label, that's legally considered drug abuse. And they wonder why many pain patients resort to the black market. Purdue was aware of this, but in order to maintain the lie that their formulation lasted 12 hours, they told doctors to stick to the 12-hour schedule and prescribe higher doses instead. What doctors should be doing is prescribing more pills of a lower dosage, but what they've learned to do, and what they're now being demanded to do by lawsuits, is to completely minimize the amount of opioids prescribed. Purdue was even responsible for one of the big revolutions in pain management, the routine recording of pain levels. This elevated pain from something doctors dismissed as just a part of disease to a fifth vital sign that was crucial to the well-being of the patient. Ever since that happened, the anti-opioid zealots have been working to reverse it. And now, it's only going to get worse. Lindell wrote, "Maybe one day we will finally realize just how damaging it has been to make people suffer needlessly by limiting opioid prescriptions. But I fear that as long as the opioid lawsuits continue, that day will be pushed further and further out into the future." Remember, opioids are the only genuine painkiller on the market. There just is no other option. So the literal torture of pain patients will reprehensibly continue. Do you have children, or nieces or nephews? Are you homeschooling, or just want to counter some of the socialist indoctrination most children get in school? If so, go to bogosity.tv/TuttleTwins, and you'll be taken to a website where you can get some great books for elementary-aged children. The Tuttle Twins books are books about liberty and free market economics that include children's versions of Bastiat's The Law, Leonard Read's I, Pencil, and Hayek's The Road to Serfdom, as well as books about the Federal Reserve and how regulations protect business cronies. They'll learn about the harm caused by eminent domain, or regulations passed in the name of safety, and fundamental concepts of liberty. And as you can see from the sample pages on the website, they're all easy to read and nicely illustrated. They're just $9.99 a piece, or get a special discount as well as free bonuses when you purchase all 5. You can even buy in bulk to donate to schools and local libraries. So get the Tuttle Twins books at bogosity.tv/TuttleTwins. And now it's time to reconceptualize this week's biggest bogon emitter. And this week it goes to Sony, whose bogus copyright claims are so bad, even a member of the European Court of Justice rejected them. Sony sued Daytel, the makers of software that could run alongside of Sony's games and change how they operate, a so-called cheat device. Their action replay software has been enabling gamers to mod their games since 1983 on the Amiga and Commodore 64, branded as GameShark in the US. Nowadays, they run on Sony, Xbox, and Nintendo consoles and portables. It's been used to push hardware beyond its software set limitations, make games easier, make games harder, cheat, and experiment. Sony sued for copyright infringement under a law that would make sense if Daytel were grabbing Sony's code, modifying it, and redistributing it, but that's not what it's doing. By Sony's own admission, it modifies variables as they exist in RAM and doesn't modify the underlying source code in any way. In 2012, the Hamburg Regional Court ruled in favor of Sony, saying the Daytel software interfered with the program flow of Sony's games, making a derivative of Sony's copyrighted code. That was overturned on appeal in 2021 and dismissed. And you thought US courts were slow. Sony is appealing that to the CJEU, the EU Supreme Court, and Advocate General Maciej Spunar published an opinion rejecting Sony's arguments. He wrote, "The value of the variables is not an element of a computer program's code. They are merely data, external to the code, which the computer produces and reuses when running the program. In the same way, the content of the present opinion is external data from the perspective of the word processing software used to draft it. Those data do not exist at the moment that the program is created by its author or when it is loaded into the computer's memory, since they are generated only while the program is running. They are therefore not such as to enable the program or even a part of it to be reproduced. We've covered before why the output of an algorithm cannot be copyrighted since it doesn't have any creative human input. If there's any creative human input here, it's by the user running the software along with Datel's device. Quote, "The value of the variables does not satisfy the criterion of originality since it is not the program author's own intellectual creation. In the case of programs such as Sony's video games, the value of the variables at issue is the result of the progress in the game and, ultimately, the result of the player's behavior. It is indeed true that the author designed the categories of the variables that are recorded, as well as the rules whereby their value is determined in the course of the game. However, that value itself escapes the author's creative control, since it is necessarily dependent on factors which cannot be foreseen in advance, such as the player's behavior. That value, therefore, cannot enjoy copyright protection." Spoonar's opinion is long and persnickety, but that's only because Sony's complaint is even more lengthy and persnickety. But his conclusion is simple and clear. Quote, "The protection conferred by that directive pursuant to that provision does not extend to the content of the variables which the protected computer program has transferred to the RAM of the computer and uses in running it in the situation in which another program operating at the same time as the protected computer program changes that content without, however, the object code or the source code of the latter program being changed." Hopefully, the full court agrees with him. Of course, the real principle here is, since you own the device, you should have complete control over everything that runs on it. It'd be nice if that were actually an option here. So all of that makes Sony this week's biggest bogon emitter. I want to tell you about the eyeglasses I've been wearing for years. As people can see on my videos, I have a very strong prescription, which makes glasses more expensive, especially when I need computer glasses, reading glasses, prescription sunglasses, and most expensively, progressive lenses for general everyday wear. To save money while still getting quality glasses, I get them from Firmoo. In fact, I just got a pair of progressives with high-index aspherical lenses and a nice pair of frames my wife loves for just over $100. It would have been $500 to get them through my eye doctor. Not only do they look good, the glasses are durable. I've worn many pairs for several years without problems. All orders come with a 30-day return policy, a 3-month warranty, and one-on-one customer service. Go to Firmoo, that's FIRMOO.Bogosity.tv anytime you need quality glasses at a low price. Once again, that's Firmoo.Bogosity.tv. And now let's graphitize this week's Idiot Extraordinaire. And it's another one for the state of California as we go back to AI stuff. This is another one about the hysteria around generative AI, which California is apparently trying to fix by telling the nerds to nerd harder. At best, SB 942, the California AI Transparency Act, is completely ineffective, born out of ignorance of AI and technology in general. Big surprise, I know. The issue here, they say, is with open source AI, so not the closed AI made by their beloved corporations. Although they include ChatGPT as an open source AI, even though it's not in any way open source. They want to require 3 things of those who make generative AI models. 1. To offer a free service allowing people to detect if content was made using their service. 2. An option for users to include a disclosure on content they generate with the model. And 3. Embedding metadata into both the file and the content, including company name, version number, timestamp, and a unique identifier. If they don't, the provider could be liable for a civil penalty of $5,000 per violation, and each day a provider is in violation is a separate penalty. It can also be elevated to a criminal penalty with a perjury charge. Now, you may be wondering how any of this is going to prevent abuse of generative AI, and the answer is, it won't. And it's not even clear how a provider could realistically comply with the law. The technology to do so largely doesn't exist. Especially with LLMs, how do you embed metadata or watermarks into a text file? A Judiciary Committee analysis of SB 942 gives examples of abuse that make this clear to anyone who thinks about it for 2 seconds, which apparently leaves out California legislators. Quote, for instance, earlier this year, voters in New Hampshire received phone calls from an AI-generated voice mimicking President Joe Biden, misleadingly urging them not to vote in the primary election in order to save their vote for the upcoming general election in November. Okay, so how are you supposed to get the metadata for an audio file when you're hearing it over the phone? As for using the tool, you'd first have to record the phone call, which is illegal because California is a 2-party consent state. You'd also have to think to record it and do so at the start of the call before you knew what it was all about. And also, remember that each provider's tool would only be able to detect a sound file made with their model. So how many would there be? 5? 10? 1,000? You'd have to upload it to each and every one until you finally got a hit and figure out which AI made it. How many would people try before just giving up? Quote, an employee of a multinational financial firm was defrauded of $25 million when he was invited to participate in a video call with several other colleagues, including the company's CFO. Or so he was told. All of the voices and people he saw on the call were AI generated and were convincing enough for the victim employee to agree to administer a secret transfer of $25 million. So, obvious problem. If he didn't think there was enough of a problem to ask questions before transferring $25 million, what makes you think he'd think to upload it to a detection tool in real time while the video call is still going on? And their third example, quote, in April 2024, a Los Angeles area high school had to investigate and expel students who were behind the creation and circulation of fake sexual exploitative photos of 16 fellow 8th grade students. If a California student shares a nude photo of a classmate without consent, the student could be prosecuted under state laws dealing with child pornography and disorderly conduct. However, these laws would not necessarily apply to AI-generated deepfake photos. These challenges underscore the need for regulatory frameworks to govern the use of Gen AI, ensuring that the public is protected from the potential harms of synthetic media. I have a video covering this on my channel, so check it out for details, but basically, determining that it's AI-generated doesn't do anything to address the harm. Everyone knew it was AI-generated. For the same reason, metadata or a disclosure won't help either. And these are their own examples. And by the way, none of these problems are addressed in their very brief arguments in opposition section. They talk about the unreliability of verifications and watermarks and how existing methods can easily be broken or forged, but they say nothing about the obvious problems I just described. It was even pretty terrible listening to the committee meeting, especially when you have proponents like Sunny Gandhi saying things like,
implement common sense safety practices.
Yeah, common sense again. It's just common sense. If you don't have any logical or rational way of backing up your proposal, just call it common sense. He even said things like,
let me be clear. We are here because our future is at stake. For 20 years, we have seen social media impact society with a cascade of negative consequences. Why would we let tech companies do the same now and set the agenda on AI?
Yeah, so this is all backed by PolitiSpeak and Histrionics. Let's hear a bit of the opposition, such as Laura Bennett.
We believe that the bill goes far beyond safeguards. It makes certain developers guarantee that they can prevent certain harms subject to significant criminal and civil liability. While we are continuing to analyze the impact of the committee amendments, specifically as they relate to liability, based on our initial assessment, we believe our issues will persist. Developer liability places an untenable level of risk on developers that are just one part of the AI value chain, as opposed to holding bad actors accountable for the harm they cause. Requiring frontier model developers to implement full shutdown capabilities and to certify, under penalty of perjury, that a model will not lead to certain outcomes, regardless of the interfering actions of a third party, is not only unreasonable, but unrealistic.
And from John Stoika,
it will hurt the innovation in California, and it will result in a more dangerous rather than a safer world. I predict that within 1 year, we will all use open source models developed overseas, likely in China. Why? Because this law will discourage of building open source models in California, and likely US. And Chinese open source models are already very competitive. Indeed, 3 out of top 6 open source models today are from China, according to our chatbot arena evaluation.
more good arguments, but it'd still be great if people actually pointed out the problems I just mentioned, especially given that it's their own examples that debunk it. Anyone remember in the 90s when the government wanted to force the same kind of disclosures on Photoshop because of all the fake images that were out there? Or the call for impossible porn filters? Or the push to require unrealistic and even non-existent filters on social media? It's always the same story. The solution to easily manipulated data is to require more easily manipulated data. The thing of it always is, the only filter that can be used to distinguish fake from real is the one between your ears. Anything else will fail and arguably make it worse because you'll depend on that instead of your own brain. So all of that makes California this week's Idiot Extraordinaire. Well, that wraps up this I Can't Tell the Future, I Just Work There edition of the Bogosity Podcast. I hope you enjoyed it. If you did, please go to donate.bogosity.tv for several ways to support and discord.bogosity.tv to join the discussion. Subscribe at the Discord or at Patreon or Subscribestar, and you can listen early and ad-free. Thank you for listening. Until next time, here's a quote from Robert Lefebvre. What you want is protection. You want to be safe. What the government does is try to retaliate after the fact. The Bogosity Podcast is licensed under Creative Commons Attribution Non-Commercial No Derivatives 4.0 International License.
Bogosity.